And we begin with that top story where the Supreme Court of Appeal in Bloemfontein has dismissed with costs the application by the SABC Communications Minister and SABC COO Hlaudi Motsoeneng. In its ruling, the court says that the public protector cannot fulfill the constitutional purpose of her office if other organs of state second-guess her findings and ignore her recommendations. The ruling was made by a full bench of justices of the appeal court in Bloemfontein. The Democratic Alliance went to the High Court to enforce the remedial action proposed by the public protector, Thuli Madonsela, and the SABC management have now to institute a disciplinary hearing against its COO. We're now joined in the studio by attorney Daniel Mantsha, who's the legal advisor of the Communications Minister. Thank you very much for joining us on the program, Mr. Mantsha. What has been the response of Minister Faith Muthambi to today's ruling?
Well, the Minister has studied the judgment of the Supreme Court of Appeals. The Minister, however, has got problem with the three fundamental findings of the court. The first one relates to the finding that the Minister did not or the Minister has ignored the findings of the public protector. The finding is difficult for the Minister because the Minister has considered the report which was prepared, commissioned by the SABC, and that report has set out a number of issues which the public protector has concluded against Mr. Motsoeneng. And the Minister was of the view that those matters were fully canvassed in that report, and her position when she adopted that report, which was prepared by Thuli Madonsela, was, in her view, reasonable and rational. Therefore, she doesn't agree with the finding of the court that she has just simply ignored the findings of the public.
But they're suggesting that she is trying to usurp the public protector's powers in a way by setting up a separate probe, and that the public protector's rulings or recommendations cannot be ignored.
Well, look, I think if there's something that this judgment of today has achieved was to actually pledge the issues relating to the public protector in a serious controversy, because the judgment came with so-called parallel processes. It's not defined in the judgment what amounts to parallel processes. And the position of the Minister is very simple. If an employer is ordered to suspend and discipline an employee by the court of law, that employer has got internal HR rules which must be followed in terms of misconduct by an employee. In this regard, what the SABC did was to ask their legal advisors to actually look into those matters of the alleged misconduct by Mr. Motsoeneng to see if there could be a disciplinary hearing instituted. And the conclusion was that there was no wrongdoing on the part of Mr. Motsoeneng.
All right, so if that's the case, are we saying that you're going to ignore, the SABC can ignore the court's, the ruling today and not institute this disciplinary hearing?
Well, I'm not talking for the SABC, I'm talking for the Minister. But what I can say to you, it is important to get clarity in a higher court whether a court of law can order an employer to discipline an employee without affording that employee, because you must remember that every employee has got a right to a fair labor practice, which is entrenched by the Constitution. So if you then have a situation where courts can order employers to discipline employees without affording a constitutional right that employee is entitled to in terms of the Constitution.
So what happens now? The SABC board was also mentioned in this ruling. Has the Minister engaged with the board, or is she going to?
Well, obviously the Minister is going to engage with the board. She hasn't engaged with the board so far. But the position is very simple. The Minister is of the view that a higher court can obviously come to a different conclusion, firstly, on whether indeed she has ignored the report of the public protector, and secondly, whether a court has got a right to impose on an employer to suspend an employee. And thirdly, what in law constitute a parallel process because an employer is entitled to actually investigate whether an employee has committed an offense. And if an employer does that, and then the court terms that a parallel process. So the minister has got problems with that because you need to establish whether the misconduct was committed or not.
Right, so does that mean that the next stop is the Constitutional Court with this matter?
Well, the next step is the higher court to the Supreme Court of Appeals. The minister is of the view that a higher court can come to a different conclusion. A higher court will probably agree with her that in fact, she did not ignore the findings of the public protector. And secondly, that it is unconstitutional for a court to deprive an employee a constitutional right to a fair labor practice. And it is unconstitutional for the court to impose on the employer to ignore its own rule and just go and suspend an employee, subject an employee to a disciplinary hearing. So those are matters which the minister thinks.
There are voices that are saying that this case is important and maybe it should go to the Constitutional Court so that the recommendations of the public protector get clarity once and for all in terms of their enforceability.
Well, I think the court in Judge Skeepers in Cape Town and the Supreme Court of Appeals. I think the position whether the public protector's findings are binding or not, I think that has been clarified, that the findings of the public protectors are not binding. But however, an organ of state cannot ignore them. So I think there is no question whether they are binding or not. I think the question is the parameters upon which an organ of state or an official of state can be seen to have acted rationally when ignoring or when disagreeing with the public protector's finding. Okay. I think that is the real issue.
So what you're saying is you can take cognizance of the public protector's recommendations, but choose another route should you find that another route is more appropriate in your view?
Well, in essence, the court is saying, when you disagree with the public protector, you must do so rationally. You can't just ignore. And what we're saying is that when we disagree with the public protector in this regard, we did so rationally. So what the higher court should clarify is what constitutes rationality under the circumstances. In our facts, where we were, the SABC was ordered to discipline a person. So the SABC was entitled to find out indeed whether there were misconduct committed. And if you come to a conclusion that there were no misconduct committed, can that be deemed as irrational or rational? And if you then say to public protector, look, I have concluded that this employee didn't commit any misconduct and therefore I'm not disciplining the employee. Can that be just ignoring? Because I think that is the biggest concern of the minister, because the minister did not ignore the findings of the public protector. She went through the findings of the public protector. She has considered all the relevant reports, and she came to the conclusion that, well, the misconduct allegedly committed on the face of the report which the SABC procured, there were no basis for that.
All right, so if Mr. Motsoeneng shows up to work tomorrow, will the SABC be in contempt of court?
No, because you see, what happened today was the appeal was dismissed, which means the Judge Skeepers' judgment, which then said Mr. Motsoeneng must be suspended and must be subjected to a disciplinary hearing, that judgment stands. But the judgment stated that the SABC must act within 14 days. So immediately, the SABC act within that 14 days and hand over the charges to Mr. Motsoeneng, so then the judgment kicks in. So which means from today until
14 days.
Yes, the last 14th day. Mr. Motsoeneng is entitled to be working until such time that those days expired, depending on, of course, what the employer, the SABC, will do. but he's well. It's free to do his work.
Okay, Mr. Mantsha, we're going to have to leave it there. Thank you very much indeed for coming in and sharing your thoughts with us. The legal advisor to the Communications Minister, Faith Muthambi, Daniel Mantsha, thank you for your time, sir.